For the record, we are recording this conversation, and this conversation does not uh, constitute any legal, tax, or investment or financial advice to anybody. Just for the purpose of chit chat and discussion. Um, between David and me. So, David, so real estate usually is a major investment for many families, especially for Chinese people. Uh, um, so, what should we all know about titling, asset protection, or passing real estate down to the next generation efficiently and effectively?
Of course. So with estate planning, it's all about having a personalized relationship together because everyone's estate plan will look vastly different based on their interpersonal with us. So strategy session looks like us providing you with oh, I just got an error message. It looks like it starts off with a relationship where we send you our intake questionnaire. The intake questionnaire is going to have all the information I need to begin assessing what the case would look like. And the intake questionnaire is going to contain all the information you already know. What are some of the assets we're looking to protect? What business interests do we have? Who are our loved ones? Who would we want to include in the estate plan? This is what I call the ABCs of estate planning. The assessment phase, where we fill out that questionnaire, I'm able to ascertain a little bit about what we can proceed forward with. The B phase is building. That's when, for those of us who sign up for a strategy session with me, I meet with you for about an hour, whether it be in my office or whether it be virtually, just like a platform like this. And we discuss in a lot more detail. What are your concerns? What are your objectives with estate planning? And after that meeting, that's when I built out a draft of what the estate plan looks like. We breathe life into a conversation and it's reduced into legal paperwork. Now, just so you're aware, the estate plan, roughly on average, is about 200 or so pages. Now, I'm not heartless. That's a lot of legalese. We provide our clients with a draft, excuse me, a summary of what all the estate planning documents mean, how they work together, and ultimately how they're structured to achieve your personal goals, whether it be succession planning for a business, whether it be planning for young children, or whether it's protecting ourselves during what's going to be, again, a sensitive time, a time when we're no longer able to provide for ourselves or our loved ones. And then ultimately, letter C is going to be the conclusion phase, the signing ceremony, where it can either be in our office or it can be done virtually. We put pen to paper and we make it a state plan that's compliant with all relevant state laws, meaning if you're in New Jersey, New York, we have our witnesses, we have our staff notary, it's executed. And the very last step thereafter is funding the trust, ensuring that working with a licensed professional, you know that your assets will be titled correctly to the trust. Banks will know exactly what type of instrument you have. Investment companies will know exactly what type of interest you have and how you still maintain that exact same interest. So, and that's a strategy session with us. See if I can read it again. Sorry.
Sorry, I don't know what happened. It seems that you just explained to everybody how you will practically work with everybody to get them to set up their trust and estate plan. And that's very nice. I think your screen was frozen for a while when I was asking you in terms of how what everybody should know about titling, asset protection, and passing real property to the future generation efficiently and effectively. After I asked that question, your screen became frozen. So
I
can
apologize.
you try to answer that question again? Uh,
Yeah, absolutely. So, in terms of estate planning, about effectively and efficiently providing the funding period, about assigning assets to the trust,
mhm,
normally for real property, this is what's called the quitclaim process, meaning that for most of us, all of our personal names are on the deeds to our home.
mhm,
So having a revocable trust having a trust instrument for that matter means that with that title in our names, we are removing our names to put the name of our trust there. So that
So
way,
let
the trust,
quit claim. Okay.
yes.
Okay.
So the trust becomes the owner of the property. We own the trust, so we still have that oversight and the ability to make decisions therein. Now, some of you might be thinking, well, does that count as a sale? Will I be subject to an acceleration clause in my mortgage? Will I have to pay anything out of pocket? Thankfully not. We are protected under St. Germain Gardens Act, which says if you are transferring property into your own trust for your estate planning purpose, it's not counted as a sale. So whatever tax rate you have, whatever interest rate you have, it's still going to be the exact same. So that's how it works with real property. And then just ensuring that everything's managed effectively is we work with banks. We provide you with assistance. We contact whatever institutions you may work with, and we advise them as to the nature of our relationship. We provide them letters of instructions to ensure that the assets under your name are effectively being managed by those respective institutions and held in trust. So it's
I see.
all localized to the source.
I see. We also, when we dropped shareholder agreements for shareholders in a private company, which will impose a lot of transfer restrictions upon their equity interest in a private company, we usually have these sort of exceptions to that general prohibition against transfer as well. Yeah.
Wonderful, exactly.
I see. And you were talking about how the whole process works. It's also similar to whatever we're trying to do for our partners involved in the same business. We will give them a questionnaire, and they will to ask them how they will allocate responsibility and authorities. This is the business that they are running. In terms of who contribute capital, who contribute expertise, and who contribute time, and to manage the business, who contribute intellectual property, and how equity, including options, things of that nature, are going to be allocated. And then you're gonna have a long questionnaire, and you answer the question, and then we will come up with the first draft, and we will go through all these hundreds of pages of documents with everybody, and then make sure that whatever we have drafted are consistent with their understanding, with their expectation, in addition to consistent with the answers they provide to us, because the answers sometimes may not capture all the reality on the ground, and then give people the opportunity to review and necessary for us to revise the document. So it sounds like the process of creating and trust and estate plan is similar. Uh, I see. That's wonderful. So, do you have anything else that you wish to highlight for everybody, or can we now open up the floor for question and answers?
Yeah, so I just have one final talk about before we open up for a little bit of a Q&A, is that one of the most common questions that I get asked is really, what do legal fees look like for this? I've talked about all the benefits of what an estate plan looks like, different ways that we can protect you, but that is going to be the overarching question that we commonly receive.
Hmm.
So what I can tell you is that having an estate plan will be the fraction of a cost of probate. For New York, probate is typically about 10, 15, $20,000, depending on the
Hmm.
value of the estate.
这个是纽约的是吧？
An estate plan with
约
us
也一般
is going to be $5,000. So again, a fraction of what probate will cost you. And even for that,
要不然怎么样？
for everyone joining us here today, normally our strategy session, to have that chance to really sit down with me, review your assets, review what an estate plan looks like for you, is normally $750. But
Wow,
because you all laughed at my bad jokes, you know, it's going to be just the 250 that gets credited to your legal fee.
I see. And but for people with sort of a more assets and or more sort of complex situation. For example, the so-called some so-called combination family, people with prime marriages and things like that. would it be much more complex and expensive to go through this kind of process?
For those complicated circumstances, that's always why we have the strategy session phase. The ability to come sit down with us to really be able to understand exactly what this process looks like for everyone, since everyone's circumstance is unique. So,
Hmm.
for your question, again, our estate plans are $5,000. But if we are talking about managing multiple business interests, if we're talking about a foreign interest, then
Uh-huh.
our estate plans can go up to about $8,000 to $9,000.
I see. So it still sounds much less than whatever they have to go through in a probate court. And I see. And
And you
also,
save months of time.
yeah. So essentially, let me try to see if I understand everything correctly. I totally regret I didn't take any trust and estate class during law school. Again, so there are a lot of people for
Yes.
cultural or personal whatever reason they don't even have a will, right? Because it's kind of a people.
It's
Uh,
taboo. No one wants to think about
Yeah,
when
people don't want to
they don't
think
want to be
about
here.
it. We live like we are immortal, right? uh, Although we clearly know we only live once, and we will also definitely die once. Okay, so let's sort of a no-no because that will is the is sometimes cause all this kind of a legal struggle between among the children and spouse and all that, right? So, but if you do it through will, and then even if the will is so-called probated, then you have to go through all these delay and expenses of the court procedure, such so that whatever bank account you have, or brokerage account have, the real estate asset you have will be sort of whatever, however it's going to be transferred will be blessed by the court and properly handled, right? And that's time consuming and expensive. So the ideal situation is to have all these kind of these trust and estate plan ahead of time so that if God forbidden, I mean it's not God forbidden, we're all gonna go one day. So when our time comes, um, we are gonna be sort of rest in peace, assured that um, sort of our will be honored and respected, and our offspring, to the extent we have built up some kind of a wealth for them, will be paying the minimal amount of tax, and then also be properly distributed to our intended recipient, and sometimes in accordance with the kind of schedule and pace that we think that makes sense for such distribution. Is that how sort of me as a student of trust estate of this first class and understand the purpose of a proper trust and estate plan?
You surmised everything beautifully, Luke. Couldn't have said it better myself.
Did I get A minus in this class? Okay, so let's
Yeah.
open up the floor for any kind of questions. Don't be shy. Just ask any question. Again, we are not providing any kind of legal advice to anybody. This is just, and if anybody is interested in, having David to do some work for them, just feel free to reach out to David, and you can leave your contact information here. And if you feel more comfortable having both of us helping you on these kind of matters, your business transaction, your business partnership, in conjunction with your, estate plan, you can also contact me so we can work as a team for you. So I suppose most of you know me. At least you have my WeChat contact. So,
直接找他就可以，right？
Peter, are you asking any question or you're talking to somebody else? So David, somebody's asking you a question through text. Can you see
Oh,
the
yes.
question?
Okay, so the question I have here is, should I open a trust account in a tax shelter state or staying with my current resident state? So really, that's going to depend And a question like this really involves that we look into what your state actually looks like, because different states have different policies and have different regulations, especially if we're talking about just using the example that's around me, New Jersey and New York. Different states have different policies, and that New Jersey eliminated Schedule B type beneficiaries, whereas New York has not. So it's a phenomenal question, but really, I'll have to give you the typical lawyer answer of it depends. Until we have an opportunity to really sit down and assess what your circumstance looks like, what your tax rate might be, it would really depend on the nature of your assets and, of course, what those two states are.
Any other question? Everybody should feel free to jump in if you have any question.
Of course, Grace, absolutely. This happens all the time. I tend to
Uh-huh.
leave the crowd speechlessly. Don't worry.
Okay, if we don't have any further questions, let's call it a night. I'm going to post the video of this little seminar, quote unquote, onto the WeChat group we have formed. And so David has left everybody with his firm's um, his telephone number.
I'm also
Um,
leaving my email address right here.
okay.
The
Uh,
message got cut off.
David, Mark is asking you, Mark Wang is asking you, do we need an executor with a trust? I think you need a trustee, right? That I remember.
Ah, there we go. Yeah, yeah. So
Okay.
you did take a class, but yeah.
No, I did not. I remember from property law classes the concept of trustee and being a corporate lawyer now, and then I do need so so what is the difference between an executor of a will or a trustee of a trust?
Absolutely. So an executor of a will
Uh-huh.
means that the decedent has to go through the probate process. When it comes to a trustee, it is a title that gets passed down to our successors, meaning for my trust, I'm my own trustee. God forbid something happens to me where I'm either incapacitated or I've ultimately passed, my wife becomes a secondary trustee. And in the very distant future, knock on wood, when we both pass, my daughter becomes trustee of our estate, and she's able to manage the accounts, the assets for herself, depending on her age.
I see. But what if somebody passes away before their children could have the legal capacity to act as the trustee of their trust?
And ultimately, it comes down to two things.
Okay.
When we have a sit-down conversation to really ascertain who in your life would you trust in that capacity until your children reach 18, 21, whatever age you decide, they become successors, or what many people do as well is they hire councilmen like ourselves to do what we call estate administration, to be
Got
able
it.
to manage the assets, protect loved ones until they reach their milestones.
I see. Okay. So, okay. Let's wait for 1 or 2 minutes to see whether there are any questions. If not, then we're gonna call it a night. Okay. Well, chat with AI companion. AI companion can answer your question about this meeting and more. Scary.
Right?
Click try it now. It's
Oh,
it's scary, huh?
yeah.
How AI is soon gonna do all of our own work. Uh, all right. I think without any further question, let's call it a night. Thank you so much, David, for your time, and thank everybody else for taking the time to join us. And happy Lantern Festival, which is the first full moon after Chinese New Year.
Ah, I see.
Okay. Thank you, David.
Thank you everyone for your time. Have a great rest of your day. Take care.
Bye.